Hi, and welcome to the Corporate Jet Investor Emergency Town Hall, looking at what's going on with FAA changes in Oklahoma. We're absolutely delighted to be joined by three experts. In fact, I'm going to let you introduce yourselves. Bob, would you like to go first?
Sure, I'm Bob Kalsu. I'm with the law firm of Crowe and Dunlevy, and appreciate being invited to join this town hall.
Brilliant. Scott?
Yes, Scott McCreary with McAfee and Taft, and I'm also appreciative of being invited.
We're delighted you're both with us. Jack?
Yeah, good. Jack Gilchrist with Gilchrist Aviation Law in Oklahoma City. Glad to be here and glad to get a chance to have a voice, I think, on this.
Okay, so Jack, you introduced me to what's happened. The FAA has introduced some changes on Halloween. Do you want to take us through what they are?
Yeah, so by memorandum delivered on Halloween, surprisingly, but the memorandum basically announced to the public that, and in this case, the announcement is to those people who operate space out of the public documents room of the FAA aircraft registry, but they told us that they would no longer make available, starting the following week, what they call work in process, as also what they call the daily log, which is also work in process, which means documents, any documents that are in between the stage of having been filed with the FAA and the FAA processing those documents. So they said they were going to no longer give us access. Their explanation, simply put, was that they may contain personally identifying information, and the FAA, as a result, feels restricted from making that information available to the public until it's been vetted. So that was basically the announcement to us.
And Bob, why is that a problem?
Well, it's a problem is when in certain transactions, you might find something on the filing index, and under the old mechanism, we could go in, see those documents, advise our clients on what those documents contained, whether they were a lien issue or any other issue for closing, and then we can make an educated decision going forward. Now, with the unavailability of going and seeing what's behind the index, showing now all we can see is that the date that something was filed and the parties who filed it, but we can't actually go and look and view the documents. So without viewing those documents, we can't advise our clients as to what potentially could be a claim of lien, a bill of sale, et cetera, that's been filed.
And Scott, on a scale of 1 to 10, how big a problem is this? Oh, Scott, sorry, wait a second, sorry. That was 100% my fault. Sorry, Scott. Would you like to try again? On a scale of 1 to 10.
Sure. Yeah. It's definitely not a 10, but it's something that we don't know yet. It's probably only going to affect a small percentage of transactions where documents have been filed with the FAA within, let's say, a few days to maybe 8 or 10 days before the next closing or the next time we need to, look at the record, and we're not able to access, the WIP documents in those instances. But that's certainly not every deal, but it will be. I mean, it will be a problem on some deals, and probably more likely issues on imports, particularly, but not every deal.
Jack, would you score it out of 10?
I don't know. I didn't hear Scott give a number, but I think I'd give it about a 6, maybe a 7. I would go with on a scale of 1 to 10. The reason is, and we've discussed this in various circles, and among ourselves, but I think the real reason that it's a problem, as big a problem as it is the uncertainty. It's the uncertainty of the FAA records. Now, as Scott mentioned, it's not going to be on every deal. It's on any deal where, again, documents have been filed but not yet processed by the FAA. And then also the uncertain part of it is that it's really unclear as to what documents we may not see. Those documents we may not see and not have any sort of any sort of notice that there are documents in the record in that case too. So I think the uncertainty, in my view, makes it a 7.
Yeah, Al, let me just add to that part of the uncertainty here is we just didn't really get any heads up or have enough. Even now, we don't have enough information to really know how quickly the documents will be provided. What is wrapped up in this whip for sure. And so part of the uncertainty is just we don't really, before this advisory or this change, we knew what we were doing. We knew how to find documents. We knew what the risk profile was for a deal and the gap period. We just don't know that now. And so, we've asked for some of this information, and I think the FAA is going to provide it, but we still don't have it. So part of the issue is we really don't fully understand what the FAAs they consider as personally identifying information, what the end goal here is, and what we're not actually seeing.
So you'd what would you score it out of 10?
As that's addressed to me, I think the non-viewing of the whip is probably I'd put it as a 4. The fact that the FAA no longer consults with us and seeks out our opinion like they did in the past, I would put it as a 10. I think that's probably even a bigger issue at this stage, is that we're just not getting the cooperation from the FAA who seeks input from the industry anymore. And but as it was mentioned previously, this isn't going to impact every deal, so I wouldn't heighten it to be above a 4 personally. But the lack of the FAA's seeking input from the industry, I would put it as a 10.
That's really interesting, Bob, and we'll come back to that. I was trying to get Scott to put a number on the line. I didn't hear what.
Oh, okay. Sorry about that. Sorry, Scott. I didn't mean to take your.
I like your 4 though, Scott.
I leave the math to Jack and Bob. They're really good at math. They were math majors.
Well, Jack went from a 6 to a 7 just in when he was speaking. So
I guess I could average. I could average it out and come to a number. But yeah, it's going to be a problem. It's certainly good for the people for the deals on which it's a problem. It will be a big problem, because the problem with the issue with our closings is that an aircraft could be grounded for several days, if not 4 or 5 days, pending our ability to figure out what's in the whip or our ability to find the notice of cancellation from the foreign registry. And so for those transactions in which it affects, it'll be a 10.
Yeah, that's why I say, honestly, that's why I say as high as I do, I put it at 7, because the minute that this lack of access and uncertainty leads to an actual problem in a transaction, that is, money's loaned or money's transferred to a seller, and it turns out that the seller didn't have good title, or the minute that, because of the fact that something had been filed in between the two, the minute that happens, it turns into an actuality. Then the problem suddenly is realistic, or a lender loans money on a multitude or number of aircraft, fleet financing or anything like that, and they don't have a first priority mortgage, and they have to negotiate to move into first priority. When it's a real problem, it's going to be a significant problem.
Okay, we've just had Gresham Shepherd's joined late and has been very honest and said, "I've jumped on late. What is the new rule?" Bob, can you explain it in 2 lines?
2 lines is that work in process documents that we can see there has been a filing made at the FAA. We're no longer to access them and be able to view what those documents are in the immediate term. We have to wait for the FAA to actually process and record those documents.
That was awesome. And work in progress files are something that, how would you describe them, Scott? They're important, but 99% of the time you don't find anything that significant. Is that fair?
No, I wouldn't say 99% of the time. It's just they are important if there have been recent filings in connection with an aircraft and we're doing our title work, or we do title work today for a closing that's next week. We would need to be able to access any recent filings today, and we'd need to be able to access any recent filings in a week from now. So if there's something that's filed between today and a week from now, we likely won't be able to get a copy of it in time for us to confirm to the parties what was actually filed with any sort of certainty in order then for them to choose the deal. So it could be something as simple as a change in their statement in support of registration that changes the signature authority of the person signing the bill of sale. And, if we would have seen that document or gotten a copy of it, we could have told the parties the documents that you're filing are not going to be recordable. But, now we can't get copies of those on an act. Well, we don't think we can. So far, I don't, we're not sure, but we don't think we can get copies of those for several days in some instances.
Yeah, and somebody mentioned, Christian Hancock, I think, mentioned the idea of a DAR and DAR's access to applications for registration, which applications were previously available in WIP. They are WIP, and they're not available at all now. So I think that's going to be a problem. You can see that something had been. I think they'll index those, but at the end of the day, you can't see the documents, so that may create a problem for processing certificates of airworthiness and so on. I think that could be an issue too.
Okay, and we're going to come back to the other questions. We've got loads, and it's great to see them coming on. It's also great to see the FAA is joining the call. So nice to see they're here. So you've raised this problem, and you've talked to your contacts at the FAA. You guys are all been dealing with them for years. Is there any signs that this could be reconsidered? Scott.
Well, I think the FAA has historically, worked with us when we've identified issues, and then, sometimes we'd like advance notice, but we understand that can't always happen. And now that we're identifying these issues, sort of like the ancillary documents, that we were prohibited access to those back, what was it, a year or so ago?
2 years ago.
2 years ago, and I think the FAA understood the concerns of industry and helped solve the problem. And we think that that's very doable here. Kind of the infrastructure that was provided for ancillary documents very well could be the solution here. Folks at the public documents room that permit these could access the documents based off of their non-disclosure agreements that they already have in place, or we could amend those to include WIP documents. But I do think the FAA will work with us. They probably might not have understood the gravity of the issue or the mechanically why it really does slow closings down in a way that will be very burdensome to our clients. And so hopefully we can provide that information to them.
Jack?
I don't yet have the same confidence that Scott does about the FAA's. Ultimately, they're working with us. I continue to think it's going to require some, let's call it, extraordinary pressure on the FAA to understand the issue, because what we've seen over the last 2 years, let's just say since COVID, basically, is this, and maybe even before that, this change in demeanor from the FAA. It's really, if you envision sort of being held now at an arm's length, I think that's one of our biggest challenges now is communication with the FAA, and they don't even show any interest in what we have to say in connection with that. I mean, generally speaking, no interest in hearing from the public or the problems. An example here, I think, as Scott mentioned, is the idea of saying, "Hey, this is the way we're going. We've got to fix a problem because we think access to WIP exposes us to releasing personally identifying information. What we're thinking we have to do is to cut off WIP. What do you think?" Right? That'd be a beautiful one, right? But there is no communication there. So there are examples of that, of course, too, as we've mentioned, the cutting us off from the ancillary documents 2 years ago, the fact that the FAA's got the public's access by phone down to 4 hours between the hours of 10 o'clock and 2 o'clock Central Time. The fact that the FAA, at least the rumors are that the FAA is going to roll out their CARES initiative even next year. but no discussion with the public about what that is, what it looks like, what we should expect. Anyway, communication is virtually non-existent. There's no real method for communicating with the FAA.
And Bob, you've touched on that. You agree with that?
I do, and just to add to Jack's point, we used to be able to obtain opinions from counsel's office at the FAA. We're no longer able to seek counsel from the counsel's office at the FAA. So I do see the lack of public service from the FAA, or the lack of public input from the FAA, being a real issue for the last 2 or 3 years.
Yeah, Al.
Scott, you go.
On the point on the council's opinions, that's also it's a great point, because historically the industry could go to the FAA and the Aeronautical Council's office and get their determination and judgment on issues like finance leases, how an aircraft should be registered, or citizenship questions and certain kind of odd citizenship scenarios. And right now we can't do that anymore. We can't get those in advance of closing. We can't get those, but those were opinions that really helped the industry make sure that everyone could rely on the record in a way that we need to. Like, for instance, if I go look at a record and an aircraft's registered to a lessor rather than a lessee in a deal, that I was pretty confident that's how it should be registered. Well, now I really don't know if there wasn't an opinion or somebody didn't really look at it more properly. So I think that ability for the industry, and especially the folks in Oklahoma City, to be able to obtain opinions from the FAA was very useful to the industry, but it also helped make sure that everything in the record was right. And a lot of this stuff it's not rocket science, but it's not cookie cutter either. There are a number of things for folks to get understand about the regulations and the Title 49 and the past history of the FAA's interpretation of those.
But you've managed without the council letters, and being cynical, we haven't seen a massive, since this change came in, we haven't seen hundreds of deals blocked, have we? Or is that me missing it?
Yeah, well, it's not a matter of seeing deals blocked. Like, we weren't having deals blocked before because we took transactions, we took trusts, we took leases to the FAA and had them view them. But a party could file, let's say, a lease with the FAA with incorrect affidavits about who should be the registered owner, because they don't understand the rules. They don't understand the lighter letter. They don't understand the regulations. They don't understand the past FAA interpretations about who should be the registered owner. And so then we get inconsistent positions in the FAA record, just merely because the industry doesn't have a chance to have it, really viewed and vetted in advance.
Yeah, and the biggest thing, and we've seen this, if I can jump in on that, is that the FAA, the aircraft registry, has now taken the position that they don't have counsel that provides insight and guidance to the industry. And as a result, they make their own decisions, and they reach legal conclusions on a periodic basis. On a daily basis, as Scott said, much of it's routine. But in many cases, they make a decision about the legal language in a document. A release, a document as simple as a release, we've seen, where the FAA takes a position that the release language is not sufficient to release the underlying mortgage interest. Well, that's a legal conclusion that they're reaching outside of counsel. I mean, they're not seeking legal counsel. They're simply discussing it among themselves and reaching conclusions, which ends up being arbitrary. It's literally arbitrary. And so that's the real challenge with that in that regard. We're a little off subject, but you got me going. So anyway.
That's good. But going back to the work in progress papers, or the work in progress files, have you, since the changes came into effect at the end of last month, have you seen major issues? Any of you? Bob?
Yeah, I haven't seen any major issues yet. I mean, there's the work in process page, and then on the RO page, you can see that something's in indexing or imaging or scanning. And so if you have an airworthiness filing that's been made, we'll see something that's been, we'll note on the RO page that it's in imaging. And so we don't have the ability to go and look and see what that is. But on a personal basis, I had not encountered a more than a couple of situations where there was something showing up either on the status of the RO page or on the filing index, which has canceled a transaction. There's been transactions where there's something on the filing index, which I know I filed because we were working on that transaction in advance, so we were able to proceed at that point in time. But we're also now coming into the end of the year where it's much more likely with the volume of transactions that we're going to see this issue come up more and more.
Jack?
Yeah, so what we have not yet seen a transaction delayed because of something that's actually been filed, but what we have done is because of the uncertainty in the record, what we've had to do is change our legal opinion, and changing the change to the legal opinion is to add the level of uncertainty that takes us out maybe as much as easily 2 weeks of possible filings that have taken place, that we've included in our opinions the language that we have not been able to see those documents, so we can't give an absolute opinion about the reportability of documents, the pre-existence of prior liens and filings. And so parties then have had to either accept the risk of that uncertainty, or they would have to have gone on and canceled the transaction or delayed it anyway. So at least what's happened is the FAA has put this new rule is they've taken they've created a risk that's not necessary. They could have avoided it, but they created an additional risk that they passed on to the parties of transactions. And I've had to pass that on in what I'm telling you is in the form of a legal opinion that was agreed to before the rule came up, but had to be changed last minute before we closed the transaction to explain it. There's added risk here that you're taking on in the process.
Scott, have you seen it?
Yeah, we've had like Bob and Jack have both said, we've had a few instances where we've had to either sort through the process, explain it to the clients, dig into it further, try to figure out if we could determine what was filed from other avenues. Either we filed it or somebody else filed it, or we've certainly had that happen. I also don't really know on imports, because I don't really know if the delay in obtaining the notice of cancellation from the foreign registry, I'm not sure what the rule is now on having access to that and when it's publicly available. I just don't understand what the FAA, the registry's position and rule is. So so again, that's why I didn't say it was a 10 when I said about it being a meltdown issue right now. But it will happen, and it will continue to happen if there's a delay in the law firms and title companies being able to access this WIP, this work in progress that we used to get access within a few hours. It will delay some closings because people will need access to that.
And there's a great comment from Christina Hancock saying, and I wish all FAA departments knew about this new rule so they can accept copies of what the title company has filed with the file stamped cover letter, specifically ferry permits. And then she's also saying, and if there are any N number, anything, it will hold the file in support first before FAA exam will look and record documents. Regular exam is around 3 weeks or so. FAA support is working 6 to 7 weeks. So if you're waiting for work in progress documents to be worked, if there is any N number work being done, that will hold it up even more. I guess you guys agree with that?
Yeah.
Mm-hmm.
Yeah, you won't see it. We won't see N number change documents, and certainly those do hold up processing of new documents filed or documents filed after an N number change request. So what we'd ordinarily do in that circumstance is we get the requesting party to rescind or to cancel the request, basically, so that we can proceed and then follow up with it after the closing. That would definitely create a problem.
And Christine's also talked, which you touched on, about ferry permits being an issue with the, very hard to get those sorted. Jack, did we explain exactly what's driving the FAA to make this change?
Well, we're told the memorandum said that it was based on the possible exposure of personally identifying information that somebody may have filed in a document, but that the FAA has not yet had a chance to review and extract from the FAA record or the document that's been filed. So it's this. What they've stated is it's a fear of that possibility. I think the possibility is, I'm going to say the possibility currently is minuscule. It's very small. We don't see. I mean, I have to say personally, I haven't even seen a case of personally identifying information submitted in the FAA record that I might need to report to the FAA to say, hey, you should extract this. You should black it out or whatever. I think, and so my suspicion then, which is just that, is that actually the FAA is really preparing for the possibility that there will be more personally identifying information in the FAA records as they move to an electronic system, which I think that problem is definitely curable also, but again, there's no dialogue on it. I think they're trying to solve problems today, now, including the ancillary file issue. They raised the same question with ancillary files, and they raised that question with ancillary files the same as they did now that it might have personally identifying information. I think myself, I think they're preparing for the possibility or the likelihood that when we get to CARES, they're going to have people submitting identifying information, photo IDs, etc., that they're going to not want to make available to the public in some ways. That's my suspicion.
Bob, do you think that the solution to this will be when the electronic filing becomes available?
You kind of broke up. Do you mind repeating the question?
Yeah. So, do you think that's when you'll find a solution to this? When the registry goes completely electronic filing?
Well, possibly, but I think there's a couple other solutions that could be had before we even get to that point in time. I mean, we've spoken about the ability to see the documents being rolled into the non-disclosure agreements that all of us at the public documents room have already executed to allow us to see those documents. The FAA could also change its process. They can immediately review the documents, pull out any of the PPI information immediately, and then go forward with the indexing. So we're not waiting on a delay. That would permit the FAA to review for any PPI information immediately and then get the document scanned so that the public can see those documents. And then thirdly, I'd point out that it's a little bit confusing to me. I mean, when we see documents and if there were any PPI information in, we would pull it out and redact it before filing with the FAA. But, in the Federal Rules of Civil Procedure in Rule 5.2, it basically states that if a person waives the protection of their information by filing it without redaction. So I'm a little bit confused why we have a certain rule in the federal court system, but yet the FAA seems to implement a separate and a different rule than what we're seeing in our federal court system.
And just for the maintenance people on the call, when you say PPI, you're talking about personal, private information.
Yes, you're correct. Sorry about that.
Not pre-purchase inspections.
That's correct. Personal identifiable information.
Scott, do you think this is all to do with the transition to being an electronic registry?
I think, well, first of all, I think that what the FAA, they're trying to address is a legitimate concern in that for privacy for some aircraft operators and owners, especially in the business jet world. I mean, there have been a number of cases where, super high profile people are being tracked and parties are able to locate where they are on any given day, which is not a good thing. But I think that, this focus on PII, in the FAA record is, like having surgery on your foot for a headache. I mean, it's not really the issue, because none of those people put their personally identifying information into the record. They all have counsel that they're careful about structures and privacy structures. So it's just not in the record. And then what it does is we have to balance this need for privacy with the industry's ability to rely on and understand what's in the record. So, what part of our job and the purpose of the Federal Aviation Act is to allow parties, one place to go search in connection with airframes, engines, propellers, spare parts of a certain size, and then be comfortable that you can determine who should be the registered owner, even though it's not an owner for, it's not a title registry, but you can determine the status of liens and encumbrances and things like that. Well, all of that requires access to the ancillary information. I mean, to who the member of the LLC is. Like we need to know that information's in the FAA record. If that changes, we need to know that. We need to be able to tell our clients that, there's a question here if they're buying an aircraft under a trust, and the trust that they're looking at, it has, Bob as the trustor, but yet it's really Jack. And all of that information is required by FAA regulation to be put in the records. So it's not like parties are just filing this information because they want to, out of the goodness of their heart. I mean, they're required to file it, and we're required to review it. And so I just don't know, I think the FAA probably needs to maybe back up and understand what, from an FAA records perspective, what PII really is important and what really should be, prohibited from broad dissemination to the public, but what has to be, available to at least the folks in the public document room permittees to properly look at title and ownership of an aircraft.
Okay, great. I thought you were going to be very diplomatic, and then you switched. We've got someone, Bob Bradford is saying, actually, Bob's asked two questions. One is, does this make title insurance more important? And will it affect premiums? Bob?
Well, I would not being a title agent, but I would assume, or title insurance agent, I would assume that the insurance agencies would accept out this particular issue as well, and not include coverage in its policy for information in which they're not able to investigate.
Jack, do you want to say anything?
Yeah, no, only that. Yeah, they're not going to insure over it. They're going to accept it under the policy that anything filed that they can't see. I don't see that. If they do, they should let us know. Yeah.
If anyone's on the call and they want to join in, they can. There's a question here, Scott. You can have this one from Tara Adkins. Will the FAA share documents if an end date? Will the FAA share documents if a non-disclosure agreement is in place with the FAA escrow agent or counsel? This was the solution last time the FAA put a similar rule in place.
Well, that's so, Jack and Bob and I and others have asked the FAA to consider that, to consider, clarifying and making sure WIP is included in our non-disclosure agreement so that we can access it for closing. So hopefully that might be a solution.
Jack?
It certainly could be. There's no reason that the concept of the NDA wouldn't work here just the same as it does in the ancillary files. So that's a solution. And as I think Bob has set out clearly too, another alternative for the FAA would be reviewing a process to review documents quickly as soon as they come in, or simply for PII information, and take care of the issue early. So yeah, one of those two would be a a very simple solution. I've likened this to killing a gnat with a hammer. Again, the exposure, the potential exposure of PII for documents filed with the FAA in the public record, by the way, is very small. I challenge the FAA to present any significant percent of information that they get that's PII that they have to keep out of the record at the end of the day. So anyway, yeah, I think an NDA could solve it quickly and easily. Practical.
Bob, did you want to add anything?
No, I completely agree with those comments.
Okay, we've got a question from Terry Spruce, which I think we've answered, and I'm just going back to the chat to see if we've got anyone else. Yeah, I think we touched. Christina Hancock had talked about ferry permits, which is a big issue. Okay, here's a question, Bob. How is it's a tight knit. I don't know how to describe you guys. You're tight knit, but also fierce competitors. The Oklahoma community. How are you guys dealing with this? You've obviously all spoken to the FAA.
Yeah, and we speak what we term ourselves the AATL, the Association of Aircraft Tile Lawyers. We communicate with each other. And we, frankly, if there's a filing, I have no problems going to the PD room seeking if anyone can volunteer information if they've made the filing. It's not that I can rely on that for opinion purposes, but at least maybe I can get some information from my clients that Scott acknowledges that he filed the document that matches up with the names and the date of the filing. This is what we believe to be the document, but I cannot confirm with certainty that that is the document. So we do, obviously we all in our lives are competitive in wanting to maintain business and seek business, but we also work well together, and that's why we come together to work with the FAA when they're willing to work with us to try to seek changes that benefits the community, the business community as a whole.
In fact, we've got a question here from Tara Adkins again, saying, when do you think the FAA will get back to you with a response on your proposed solutions?
Let me jump in. It's interesting because I think it'd be fair to say, among us at least, and let's just call it the Oklahoma City industry, even outside of the AATL. But when we talk about when will the FAA get back to us, there's nobody communicating with us directly. I mean, I would suggest that those people communicating with Bob are possibly different than those that are communicating with Scott and those that are communicating with us. We're not getting any direct line of communication. We've approached the FAA's personal or exclusive in-house counsel and with the question and raised it there, though they're quick to say they don't really have they don't control those decisions in connection with that either. So it's if you looked to the registry to say who's speaking with the industry, it's kind of like we're getting rumor, basically, and you get some decisions along the way. So it's difficult to say who's speaking for the FAA. We're hopeful that we will continue to press and that whomever at the FAA is making decisions will come to the table. That's all we'd ask, honestly. Let's just come to the table and talk about this. Have a communication with the public about it. Look, this group of lawyers here and those many great people that operate title companies out there too, we represent probably some 90% of the filings that go on. I don't know what it is really, but so for now 35 years for me and a long time for these guys, we've worked closely with the FAA. We used to have them come. They used to come to meetings with us and they talk and discuss and we banter about, hey, how do we solve the problem? It was a much better world at that point. But anyway, so when they'll do that, we're going to keep pressing because I think the current state is too much uncertainty. That's my feeling about it.
Yeah, Mike Francis, I think, asked the question just seconds before, actually, Scott. So you've got no visibility in when the FAA is ready to start a dialogue with you on this?
Right. That's right. I just want to, to be a little more politically correct here. You said that I wasn't last time, but, I will say this is not completely out of the blue for the FAA. So again, the FAA, they've had a lot of push from industry to limit PII information for these ultra high net worth and, famous people that are being tracked. So that there's been a push from the industry for that. And the CARES program and the FAA audits have required, putting this information in public record, which has caused them to analyze the personally identifying information they have. But, as recently, I think it was May of this year, in the FAA Reauthorization Act, Congress literally directed the FAA to address PII within the next 2 years. So it's not that this is just coming out of the blue from the registry. They're trying to work through a complex set of facts and scenarios to, limit PII, but yet let, people do deals. And what we're trying to do is just make sure they understand that these slight changes could have and does have big effect on the industry and our ability to close transactions, at the end of the year. And so hopefully we can, we will work this out where there's a solution. But to answer your question, no, I don't know when we will hear back from the FAA.
Mike Francis was asking if NBAA and others like NAFA, IATA, GLADA are providing assistance.
Yes, they're all focused on it and doing what we're doing now, just kind of waiting to see how, what actually unfolds here in the next few weeks. But big picture, yes, everyone needs to be able to close a deal consistently and quickly and have access to the information as quickly as possible. So they're focused on it.
Ford von Wisey has asked a really good question, which I should have asked. We've talked about the CARES program. What is it? Bob?
Yeah, CARES stands for Civil Aviation Registry Electronic Services. And so it's basically the web-based system that the FAA is developing to allow parties to submit aircraft registration applications and airman certificates, et cetera, online via electronic filing without necessarily having to go through the bin drop box at the public documents room at the FAA.
And I'm putting you on the spot, but when was it? We've been talking about CARES for quite a long time, haven't we? On this, when was it meant to happen?
Oh boy, Jack and Scott can help me out when the FAA intended for it to happen, but it has been a slower rollout than I think anticipated. There are certain aspects of CARES that is now available online, but the full gamut of what I think they fully anticipate is not available online at this point in time.
Yeah, I think their target, I don't remember exactly either, but it seems like it was back in the 2017 or something was the target. And they actually, and also too, sort of had as an initiative in front of them, a lot of push, governmental push for them to come up with an electronic system, I think. But it's a complicated process. We've said all along though too, that again, if they roll out an electronic system without any input, it is literally without any input from the industry. And when they do, it's I don't know, we'll be interested to see what it looks like. But it seems to me that rolling out the electronic system without at least some input and insight and discussion, dialogue with the industry that uses it, it seems to be a complication too. But it's basically an electronic filing system to make records available electronically. And then I think we understand so far that there will be some qualifying process for being able to actually file documents, proof of who the parties are and that sort of thing. So some level of identification presented to go through that process.
we had a question a minute ago from Mike Francis asking if NBAA is involved. Melissa Felix is saying actually they're working with the Sam Graves and Rick Larson, two congressmen who head the U.S. House Transportation Infrastructure Committee, and they did a fantastic presentation at NBAA base, or a fantastic fireside of Ed Bowden talking about how they had got through the FAA reauthorization bill. So that sounds very positive that they're working on this. They were both very impressive. One Republican, one Democrat. Great to see them working together. Presumably, you'd take comfort from that, Scott.
Absolutely.
Okay, Bob, you touched on earlier. You said you were worried out of 10 out of 10. You were worried that this had happened without the FAA consulting you. Do you genuinely feel that maybe since COVID, the FAA's relationship with industry has not been as strong as it was beforehand?
Well, yeah, I mean, I think that's true, and just from what we've evidenced, and that being the fact that we no longer can seek counsel opinions from FAA counsel's office, the fact that they've shortened their lines available to the public to call the FAA registry to seek guidance. So we've seen different actions by the FAA without input from industry that has reduced the industry's ability to communicate with the FAA. So I don't think it's a personal opinion. I think it's just factual that the FAA has reduced its availability to the public, and it continues to seem to go down that road.
Yeah, another example of that too is if you think about this. So documents filed with the FAA are part of the process. Late in the process, they're assigned to an examiner, and that examiner has the ability, and understandably, the examiner has the ability to reach out to the party filing the documents. They don't often do that. They often will simply go through the process of rejecting documents for some reason that they found problematic, send the documents back, and then often we explain to them what, and I'm sure Scott and Bob and their firms do the same thing, explain to them that why the documents that have been filed are recordable, or they should process them as they're filed. But we have no ability. In fact, it's forbidden to contact the examiners, us to them. It's generally speaking a one-way street. Now, if an examiner calls and leaves you a message to call back, then you can do that. But you can't contact them. Now, again, understand the disruption that it creates when an examiner has to answer the phone or go check on somebody else's work or whatever the case is. But there's no method for even, you can't email an examiner. All the email goes through one email deposits box, basically. And the another great example is there's no process they didn't reopen the process to file documents through the window where you can get your file stamped documents back, or you can get the file times immediately. It's like, we want to drop them in the box outside the door, and we'll come get them when we feel it's safe to come out there, or something like that. But anyway, the whole process, much about the process has changed from COVID, that they have not changed back. So,
Scott, we've got so many different people who are involved in transactions on the go. What advice would you give to them to try and avoid these problems going forward until there's a solution?
Yeah, so I think they need to, like in their agreements, be forward thinking about how they'll handle the delay if there is a delay. Like if there's an import, you need to understand there might be a delay before the parties can see the notice of cancellation from the foreign registry. And so they need to kind of understand and look at that. Probably hire people that know what they're doing, here in Oklahoma City, to help look at the records, to help understand what is and isn't in WIP, and look early. Don't wait till today and then try to close the deal on Monday, and you're not going to get the WIP by Monday to know what's in the record. So look at it sooner rather than later, and then just be patient, because the folks in Oklahoma City can only tell our clients what we know and what we have physical copies of, and we're just not going to have physical copies of some of the records if there have been recent filings.
And Bob, presumably one of the issues is that when you've got a deal getting close to closing is when you suddenly realise that actually you haven't been up to date with all your filings. So you tend to.
I think the real problem comes, we can identify when we understand there's a transaction upcoming, and hopefully we've been given notice. We can run those searches and identify that ahead of closing. The real issue comes when it's time to close, and you bring down your searches immediately prior to closing, and then you find there's been documents filed in WIP, and we can't find it, and everybody's queued up to close. And now all of a sudden we have to put the brakes on because there's something showing up in WIP and we can't go and see what that document is. So we can do everything we can ahead of time, but there will be those situations where immediately prior to close, when we bring down our searches, it'll put the brakes on transactions.
And Jack, it's Thanksgiving soon. We've got probably a month left for people trying to close deals by year end. Do you see this having an issue?
Yes, I do think it will be an issue from time to time. It at least is an issue in connection with what we can't see in the record again. And I think one solution, particularly for the private aviation industry, we deal a lot in commercial aviation also, but in the private aviation industry, it may even be prudent to write into purchase agreements at this point obligations that may come up unanticipated as a result of this issue, so that the seller has to cure issues that the parties didn't foresee. I think that's one thing that may be valuable, because you may have a buyer maybe the buyer's looking for an excuse to walk away, or the uncertainty of it, and the time has run out for closing and that sort of thing. I think it may be necessary to write into purchase agreements this possibility of delay of records and the need and the requirement of the parties to cure issues after closing, after the delivery, after the money's changed hands as well. Just one more thing on the commercial side, this is as much a problem for the commercial aviation industry as it is for the private aviation industry. So the commercial industry will also weigh in on this subject very significantly, based on the fact that of this uncertainty. Again, you can't make a $140 million fleet financing or offering basically and not have certainty as to your priority in your filing. We do say one more thing real quick, and that is also we do have still as a positive. I think there is an emphasis that needs to be made on the international registry and the ability for us to make registrations on the international registry can help in connection with the issue of priority of liens, mortgages, title transfers, that sort of thing. So the idea that the international registry should be, at least be an afterthought is a mistake. It should be a thought in advance, because people can make prospective international interest registrations to help cure the possibility of an intervening filing registration in the transaction.
We should note, though, too, Jack, that only it doesn't apply to claims of lien and other sorts of actions. And so it only is protective as it pertains to consensual arrangements.
Yeah, that's a good point. And you can't, so the mechanics lien or artisan's lien, non-consensual liens in the U.S., certainly there is not a provision for registering those on the international registry. So you could easily have a perfected non-consensual lien that could take priority over a mortgage. That's right.
Okay, before I ask you each a stupid question, Bob, what's the takeaway everyone should take from this?
Well, I think the takeaway is that, to be prepared, understand the issue, understand that it could cause delay in your transaction. And then also I think the real takeaway is for industry to get together and ask the FAA to reconsider and find solutions that the industry and the FAA both can be satisfied with.
Scott, do you want to add anything to that?
I would just say, keep perspective here. I mean, it's an issue that we need to address. The industry needs to address, but we're still going to close deals. The FAA is still great registry. I'd say the best registry in the world, and it's all going to work out.
Jack?
Well, I love Scott's positive outlook on life. I always do. And I feel the same. I mean, I do feel the same that we'll solve the problem. I like Bob's comment that I think I don't like double negative here. I don't like not being heard. Right? I think the industry needs to be heard, and we need to hold our breath until we get heard. I think that's important, and I think that's valuable. But I agree with Scott, particularly in the sense that we will continue to get deals done. And a good example of that, real quick, is looking at financing leases. What's happened with financing leases is we've taken on the obligation that we used to get help from with the FAA, and we've made a commitment in our legal opinions, for instance, as to how registration should take place on an aircraft under a financing lease. But we get deals done. We've done it here now as well under this circumstance. But here, the difference is it's not necessary. The FAA can solve this problem. So keep the faith, keep the pressure on. I think the FAA should reconsider the issue.
Okay, that was a great answer, and that was the important takeaway. But if you had to go to a different registry, if you had to leave Oklahoma, where are you choosing, Jack?
I'm going to go to the Bahamas. I think if I have to go someplace else, I'll change my practice to the Bahamas. My wife will come in a heartbeat.
Scott?
Cayman's always fun.
Cayman for sure, yeah.
Bob?
As long as it has beach and sunshine, that's all that matters. Beach, water, and sand.
You'll find us all better, sure.
I was going to say the Isle of Man's got beaches. And it's beautiful if you get the 3 days when it's sunny. Thanks so much, guys. Really fantastic to have all of you raising this. Have a great Thanksgiving. You all deserve to have a break. I hope you're all taking it off. Thanks so much for everyone for joining us. Have a great Thanksgiving if you're in America. If you're in the rest of the world, keep working. And thanks very much. Wherever you are in the world, good afternoon, good morning, good night. Thank you.